My name is Lena Wahlberg, and I am an associate professor of jurisprudence at the law faculty in Lund. And I will talk about the room for clinical innovation under Swedish law, and I have been asked to reflect specifically on the question, what is the regulatory environment concerning unproven methods in medicine in Sweden? And I would like to start with saying that I think that the notion of unproven methods is a quite complicated notion. It's not a legal notion. It doesn't have any determinate meaning in the law, and it does seem to be ambiguous outside the law too. So here are just some interpretations of what we might mean when we talk about unproven methods. And of course, the room for unproven methods, the regulatory room, depends on what we mean by unproven methods. And I will return to this question later during the talk. But I will start with the regulatory framework in Sweden. This is a simplification of the regulatory framework, but it shows the fundamental distinction that we make between healthcare on the one hand and research on the other. In addition to this, there are many other rules, for example, regarding the approval of drugs that we talked about this morning. I will not go into them today. Instead, I will focus on this very fundamental structure. So what requirements apply depend on whether what we do qualify as healthcare or whether it qualifies as research. So within the healthcare regulation, or the healthcare column here, it is required that treatments must accord with science and proven experience. So this is the fundamental standard of care in Swedish law, and it's an old standard. It goes back to the 19th century. And of course, this is what predominantly limits the room for unproven methods in Sweden, in Swedish healthcare. In research, on the other hand, there is a pretty large room for unproven methods. You don't need to meet the requirement of accordance with science and proven experience when you are in the research framework. However, the research regulation requires planning. You need to have an approval from the Swedish Ethical Review Authority. And in order to get that, you need to file an application. You need to have a clear research plan. And you need time for the approval. So you need to know what you're going to do. There is no room for spontaneity in the research regulation. I will actually not talk about the research framework today. I will talk about what the room is for unproven methods within healthcare, namely the room for unproven methods without ethical approval. And I have 3 questions that I will discuss. The first question is, are there any exceptions from the requirement that the treatment must accord with science and proven experience? And the second question, which is the most important question, I think, is, what does the requirement to accord with science and proven experience more precisely mean? And then the third question, what are the expected legal consequences of violating this requirement? And I will begin with the first question here, and I will start by positioning myself against a conception that I sometimes or quite often meet among healthcare workers of the room for exceptions from this requirement of science and proven experience. So this picture here is an illustration of the common, but in my view, incorrect conception of the exceptions from the requirement of science and proven experience. So here we have healthcare, which must accord with science and proven experience, and then we have research, for which we have to have an ethical approval. But then, or so the conception goes, we have this very large room for exceptions, treatments that do not qualify as research and hence do not require an ethical approval, but that nevertheless do not need to accord with science and proven experience. And this exception can be justified by reference to vital indication or compassionate use or something else. And this, in the exception, this is a gray zone between healthcare and research, and this is where we find the unproven methods. The problem with this conception is that from a legal point of view, it's very hard to find support for a large exception from the requirement of science and proven experience. In fact, in order to argue for a legal exception, you basically need to be in a situation where there is an acute emergency situation. So I would say that the more adequate picture of the Swedish regulation is this. So we have the requirement of accordance with science and proven experience in healthcare, and we have a small possibility of exceptions from that requirement. And moreover, the research regulation overlaps with the healthcare regulation, because if you are studying a method that does accord with science and proven experience, because you want to know what its effects are in more detail, then you are conducting research at the same time, so then you need an ethical approval too. So this means that the important question to answer, in my opinion, when you want to know whether there is room for unproven methods, is the second one here. What does the requirement to accord with science and proven experience more precisely mean? And this is $1 million question. I can just mention in passing that I'm working on a research project on this question, and James and Garland here in the audience is also working on a project on this question. Here are some possible candidates for interpreting the notion of accordance with science and proven experience. And if you paid attention a couple of minutes ago, and if you have a good memory, you will see that what I did here is just that I removed the negations from the slide showing the possible interpretations of unproven methods. So according to this interpretation, a method accords with science and proven experience if it is a proven method. This would mean that according to this understanding, unproven methods are by definition unacceptable. Personally, I think that this interpretation of science and proven experience is too strict. And I have several reasons for that. One reason is that I think that this interpretation seems to be a bit hard to maintain. So for example, if we say that only established clinical practice qualify as being in accordance with science and proven experience, how then could we ever introduce a new treatment method? And if we say that only treatments that are recommended by the government accord with science and proven experience, how then could we handle the areas in which there are no governmental guidelines? So I think that we need a more relaxed interpretation of science and proven experience than just to say that it means proven methods. And if we look in the sources of law, there is quite a lot there indicating that this is a too strict interpretation. And I will just give a few examples. Sources of law, for those of you who are not lawyers, are legal materials that we use to interpret the law, such as case law, precedents, and preparatory works, governmental bills, and so on. Here is a quote from the Swedish Board of Health and Welfare. It's an old one, but it's frequently cited in many preparatory works as well as in much case law as a possible definition of the requirement of science and proven experience. So what are they saying here? They say that the medical doctor must consider both science and proven experience. And then they say that when a method is new, proven experience is lacking and scientific evidence suffices for acceptance. So, okay. It doesn't seem to be an absolute requirement that a method is established clinical practice to meet this requirement. And then they say that at other times, long clinical experience is the most important evidence for acceptance, whereas theoretical and/or experimental evidence is lacking. So they also seem to say that, okay, but sometimes we don't have that much scientific support, but something can be acceptable to do anyway. There are also some statements, so quite a lot of statements in case law, suggesting a more relaxed interpretation of science and proven experience. Here is a recent example from the Stockholm Administrative Court of Appeal. And this case was discussing the question whether the use of botulinum toxin as a treatment of hyperhidrosis in other body parts than feet, hands, and armpits was in accordance with science and proven experience. And this treatment had been given at a private clinic in Denmark, and the local guidelines at the hospital in Sweden did not recommend this treatment on the other body parts. And there were no governmental guidelines here. There was an expert physician at the Swedish Social Insurance Office, and he said that no, it did not accord with the science and proven experience to treat other body parts in this way. So what did the court say? Well, the court said that, well, the mechanism by which botulinum toxin impairs sweating is known, and we can assume that it will work in the same way on other body parts as it does on hands and armpits. And in Denmark, at the clinic in Denmark, botulinum toxin has been successfully used on other body parts for several years. And hence they concluded that the treatment does accord with science and proven experience. So, I mean, you have to be careful with the conclusions you draw from material like this, but at least it suggests that sometimes, under some conditions, some of the methods that we call unproven can be in accordance with science and proven experience. And the tricky question here is, of course, to say, okay, but when do they accord with science and proven experience? And what then does the requirement of accordance with science and proven experience mean? I think that the most plausible interpretation of this requirement, it might strike you as trivial, but I don't think it is trivial, is that there must be sufficient evidence that the treatment is safe and effective for the patient. So that, in my view, is the most reasonable interpretation of accordance with science and proven experience. It's not explicit in the legal sources of law, but if you make a teleological interpretation of what is said there, this seems to be a reasonable interpretation. Now, this doesn't mean that anything goes just because the patient is dying. We have heard earlier today that there are better or worse ways of dying in, or that anything goes just because we don't have an established treatment method. What it requires is that the expected benefits for the patient must outweigh the risk. So you must take into account all the available evidence out there and come to the conclusion that, yeah, the benefits for the patient outweigh the risk. But I can see nothing in this requirement saying that it must be a phase 3 level of evidence, for instance, but you need to make a risk assessment. And furthermore, and I think this is really important and quite often forgotten in the discussion, the use of unproven methods can be justified only by the expected benefits for the patient, not by the new knowledge they may bring. Knowledge is a relevant interest in the research regulation, but it's not relevant when you are in the healthcare regulation. There it's only the interests of the patient that matters. In order to bring in the interest of knowledge, you need an ethical approval, and then the ethical committee will make that balancing. Okay, so what would this mean then? Well, it would mean that there is some room for unproven methods without ethical approval under Swedish law, provided that the expected benefits for the patient, all things considered, exceeds the risk. There is no room if you interpret unproven methods as being methods for which there is no sufficient evidence, then you can't use that interpretation. But if you interpret it in other ways, there is some room. However, we need to be very, very cautious here, because normally unproven methods will not be supported by sufficient evidence for safety and effectiveness. So consider clinical experience, for instance. Psychology has taught us that experience is not a reliable guide to knowledge. We tend to suffer from different kinds of biases when we interpret our own experience. And this is why we normally will need scientific evidence too. Furthermore, the risk assessment that this interpretation requires, it's hard to make. It's not really clear what sufficient evidence means. It's not clear what the evidentiary value of an isolated study is. And there is a clear subjective element in any risk assessment. And finally, there is no guarantee that this assessment will survive a subsequent trial, that it will stand up in court. And this leads us to the last question I would like to touch upon, namely, what are the expected legal consequences of violating this requirement then? And here I have added a new row to the picture I showed in the beginning with consequences of violation. And we have criticism by the Health and Social Care Inspectorate, we have license withdrawal, probation, criminal liability. This is not exhaustive, but some important consequences here. My impression is that consequences of these kinds are quite rare when it comes to the use of unproven methods. These consequences, criticism by the Health and Social Care Inspectorate and license withdrawal and so on, they do occur, and I think we will see them more often in the future. A couple of months ago, there was surgical procedures of a kind that was not established clinical practice in Sweden, but for which there was some scientific support. And the inspectorate said that that kind of surgical procedures did not accord with science and proven experience, and then they criticized the physicians for doing that. There are also examples of physicians who have prescribed antibiotics, for example, for longer time than recommended in the guidelines, and they have lost their license, not only because they used an unproven method, which they claimed was legitimate, but also because it was poor documentation and poor diagnosis in these cases. But what I'm saying here is basically that the first things here, they do happen. But what never happens is this. I mean, criminal liability for unproven methods is essentially unheard of. And the telling example is the surgeon at Karolinska Institutet in Stockholm recently, who transplanted synthetic tracheal prosthesis. Is that okay pronunciation? You know what I mean anyway. And what he did was not, he didn't have ethical approval. The general view was that it was not in accordance with science and proven experience, but they couldn't convict him. They could not convict him for violating the research framework because too long time had passed and there was a statutory limitation of 2 years. They could not convict him for violating, oh, I think I'm losing this, but I will work it out, for violating the healthcare regulation, because in order to do that, they needed to show a causal relation between the transplantation and the patient's death, and that was really hard to do, considering that the patient suffered from a serious illness to begin with. So it was not that what he did was okay, it was just that there is some kind of inbuilt mechanism in penal law here which makes it ineffective. So, well, the final word isn't said here yet because the case has been reopened, but we will see what will happen here. So, to summarize what I have said, there is some room for unproven methods without ethical approval under Swedish law, but it's limited and it's not unequivocally demarcated. It's hard to say exactly when we can use an unproven method, and it's not the case that anything goes. The use of unproven methods can be justified only by the expected benefits for the patient, not by the new knowledge they may bring. Ethical approval is required when a treatment method is studied scientifically, even if the method accords with science and proven experience. But the risk for criminal liability in case of violation of these requirements has so far been very, very low. I was asked, and I have 1 minute and 6 seconds to go, I was asked to reflect on these two questions too. I suppose we will discuss them more during the panel discussion, but I will reflect a bit on them anyway. First, does the legal environment promote or stifle the development of unproven methods? I think it might stifle clinical innovation, but I think it's also important to say here that whether it does so or not does not only depend on the regulation, but it also depends on researchers' willingness to prepare their research projects in good time, to apply for application to the ethical committee and to know what they are doing. If researchers are prepared to do that, then they can try unproven methods within a research project. So what it stifles is perhaps spontaneous innovation. And then the second question, should we change the laws? We should discuss that, but I would like to make 2 remarks here. I often hear the argument that many of the useful methods that we use today and much of the knowledge that we use today is a result of clinical innovation. But the fact that a method is useful does not by itself justify how we got it. I mean, just consider Nazi experimentation, for instance. No one would claim, even if the results would be very useful, that the usefulness of the results justified the way we got them. I would also like to say that the argument that many of the good methods we have today are the results of clinical innovation does not mean that we can't get equivalent knowledge in the future without spontaneous innovation by using a planned research project instead. So I don't think, I think that this question is sometimes presented in a too simplistic manner. What I think is the major problem with this regulation is rather the uncertainty here. It's unpredictable. There is a lot of legal uncertainty, and legal uncertainty, in my opinion, is almost never a good thing, and this is not an exception. So this is what I had to say. Thank you very much. In case you're interested in the research project I'm working on, you can visit the web page there. Yeah, thanks.
Yeah, I agree with the separation of healthcare and research. However, if we take a historical perspective, that this hasn't really been the case. And you know, if we take the entire volume of scientific literature from the past 4,000 years, you know, probably 95% is serious case reports, which means that the patients were treated, you know, to try to help them, and then retrospectively you analyze what happened. And even the Declaration of Helsinki points out that regardless if you do a clinical trial or, you know, a treatment, you should try to publish the data.
Yeah, but that is something else, that you can gain knowledge from healthcare and you can write about it later. But if you do it as part of a research, then you're in the research framework. But there is no, I mean, it goes without saying that you can learn from what you have done in healthcare.